on what the governor is responding to. Allow me to deal with charges 1, counts 1 and 5 together. These counts are found in the Assembly's documents, Volume 1. Count 1 has 4 specific allegations. Allegation number 1, that the governor has violated certain provisions of the Constitution and the law. They are specified there, I'll not read them, by engagement, connivance, and stroke or complicity in the following. First, honorable senators, allow me to tell you this charge is duplex. It is a defective charge. If not for anything else, Mr. Speaker, sir, this means that you must discourage this form of drafting. It is poor drafting. The governor has to elect whether she is going to defend herself against engaging in those acts, against conniving in those acts, or against complicity in those acts. In law, that's an impossible task. The Senate, my apologies, what the County Assembly has done is to cast a wide net, in the words of the fishing vocabulary, in the hope that it may catch crabs, fish, and perhaps some snakes, so that you say, anyway, we may have grabbed a lot of snakes, but there's one fish, so vote for this fish. It's a poor way of dealing with a case of this nature. A case of this nature requires military precision in the charges. Be that as it may, the governor is accused of doing those things in the form of embezzlement of county funds through the governor's sisters, Rose Kenya Gwantai and Miriam Gwantai, brother Kenneth Gwantai Muragiri, brother-in-law Nefat Kinywa, and nephew to the governor's husband, Edwin Mutuma Muragiri, all of whom are now collectively referred to as the governor's relatives, period. So the governor comes to this court and says, no, I want to give you evidence to show that I have not embezzled any funds through these people. How will I do this? I will give you vouchers to show what each of these people is being paid for. That is a sufficient answer to this charge. You are then told, no, he has not accounted for 70 million shillings. Honorable senators, where is the charge for failure to account for 70 million shillings that the governor is supposed to respond to in that form? Number 2, where is the charge of failure to account for 78 million shillings? Because if that charge came as such, then the governor would have been under an obligation to secure her finance people, to give her material in respect of all the 78 million. Then we can interrogate the material one by one. Is this credible? Is this not credible? And so forth. Once we have supplied that, we must show a causal connection between that money and the person of the governor. The governor was taken through a fairly humiliating exercise. She was reduced to a clerical officer. You are senators, you are state officers, you get impressed. You know the clerical process of dealing with a single impressed at a time. Mr. Speaker, sir, if you are personally to be held responsible for the impressed process in this house, would you possibly transact the business of this house? That is a matter this house must reflect on in your private moment before you take a vote. Even the clerk, who is the administrative head of this house, if he was told to personally explain each of the individual signatures in every signature of 100 vouchers, would that be possible? Allow me to tell you why this charge is premature. An audit process presents a different environment, because an audit process, the auditor comes, receives documents, reviews them, asks questions, People go back to the drawing board, review their own material, come back. The whole process takes time until we have a report. Now here is where you file documents and you are bound by those documents. There's no feedback. So in this case, we have no audit report. The county assembly should have been patient for the auditor to audit these accounts, raise specific audit queries, fail to get answers to those audit queries, then mount a case based on the specific audit queries that are not answered. What has happened by council for the assembly before you is a sad commentary on how not to prosecute an impeachment motion. The governor is accused.
Council, you have 15 minutes.
That's okay, Mr. Speaker, sir. Thank you so much. The governor is accused of withdrawing county funds under the guise of payment for various supplies by the governor's relatives, yet they, the governor's relatives, are ineligible to tender for or supply any goods or services to the county. Council for the assembly, in cross-examining the governor, completely misled this house, and I was saddened because council have a duty of candor. Despite our sectarian interests, council have a duty of candor. When you retire, honorable senators, look at volume 2 of the county assembly's documents. When you look at volume 2 of the county assembly's documents, you will discover that from page 1 to page 29, from page 1 to page 29 is a letter by Turanira Salesio Mutuma to the Ethics and Anti-Corruption Commission and some attachments. That is crucial, honorable senators. Among those attachments is a table prepared by the said Salesio, running from page 4 to page 14. Page 4 to page 14 is not an IFMIS extract. Page 4 to page 14 is a table prepared in Word format, in Microsoft Word format by Salesio. That's important because that question was put to the senator as if this is an IFMIS extract. It is in this table, good senators, that at page 6, in row number 4, you will find an entry called hospital supplies. This is Salesio writing those words. It is not IFMIS in which this is entered. It is Salesio. A person who was not brought here, we were wondering whether he's a real human being or he could just be taking care of his goats somewhere. At page 11, in row 3, you will find hospital supplies, another entered record by Salesio, not from the IFMIS. The governor's case before you is this, that if you proceed to page 17 to 29, where the IFMIS extract is, and you look at the corresponding voucher numbers to these things Salesio has written, you will find in the IFMIS extract, these are hospitality supplies. That's the governor's case before you. So the impression created by my learned colleague, Dr. Mudomi Thiankolu, that this entry hospital supplies is an entry made by the county staff in IFMIS is a pure lie, sadly from council. When you continue looking at those charges, I'm more interested in count 1 because the other counts, they are the kind of counts that I can say fall on their own weight. But this one here, somebody tried to point at invoices in a manner that was rather frustrating for anyone who understands this process. In fact, when I sat where I was sitting preparing my submissions, because I was not in this house, I presumed that either counsel for the Assembly did not understand the impress system of government. Fortunately for us, this Senate works on impress systems. Count C, sorry, allegation C. Sorry, Mr. Speaker, before I forget. So the charge here is making various supplies, and that's why we supply only vouchers that show you what these payments are for. They are not for supplies. They are for particular recurrent expenses, that's all. So we are not accounting for 78 million shillings. We are just responding to this allegation. Thirdly, we are accused of paying full salary and benefits. In fact, those vouchers and those IFMIS entries are only relevant in respect to allegations A and B. When it comes to C, I have already mentioned to you that these payments were made pursuant to a court order. The lesser I say about that, the better. Count D says diversion or misuse of county resources, including funds or motor vehicles, to run the governor's private entity. You asked yourselves, which motor vehicle? You are told no. Go to the affidavit of police constable. You'll get it there. A very strange way of identifying a motor vehicle. I'm open to learning. I was not willing to learn that one. Allow me to demonstrate. Sorry? Mr. Speaker, do I understand I have 10 minutes? Thank you so much. The governor was accused of nepotism and related unethical practices. Before I argue that, when counsel for the county assembly, Mr. Ngwele, stood here and told you that they have proved that Kathure Rukania is among those who are paid money that's not accounted for, I asked myself, look at the 39 allegations before you, 39, and point out to me where the name Kathure Rukania appears in the 39 allegations, so that the governor can now take the task of explaining him. The county assembly has taken a strange stance before this assembly. I'm saddened if this is the trajectory of impeachment. Charge 2 is about nepotism and related charges. One of the claims here is that the governors send her unqualified technical team to China. Even when the county assembly witnesses are given their own documents saying the purpose of this trip or this request for clearance was to prepare and guide on the visit. They will express words. They insisted that no, ignore those words in their own documents. They were shown the invitation letter to China at page 79 of volume 2 of the assembly documents. They were asked, show us which part of this invitation is inviting technical cancer experts. They were unable to show it, but they have come here in closing submissions to insist that that was the nature of the invitation. It is a rule of ethics in trial advocacy that an advocate must never submit outside the evidence. Counsel for the assembly have breached that rule of ethics. They have said that the governor misrepresented to the Minister of Devolution that these were technical people. They are told, okay, these people are said in a letter dated 29th May 2023 to be technical staff. Who is technical staff? Isn't the governor's security a technical security staff? Isn't the governor's PA a technical administrative staff? Where was that word technical staff defined as a term of art? They can't show you. Then they say, we ask them, okay, the next week, the same county government writes the Minister of Devolution specifying these people's names and their designation, which you confirm is correct. So if they intended to mislead, Where are they now clearly spelling out these people's designation before these people travel? They can't answer, but in their final submission, they still insist there was misrepresentation, a poor way of advancing the jurisprudence on impeachment. You'll be told this nepotism is in the engagement and employment of Edwin Mutuma Murangiri, a nephew to the governor. I've spoken about that. The lesser I say about it, the better. Nefat Kinyua, the governor's brother-in-law, in public knowledge. I mean, what kind of behavior is this? Assigning diplomatic duties. You'll be told the evidence that diplomatic duties were assigned is in a Facebook post. You are told, okay, read that Facebook post. Where does it assign diplomatic duties to the governor's relatives? It is not there. It's those pictures you see there. If you look at them carefully, they are speaking. Those pictures are speaking about diplomatic duties. Surely, a Senate to be engaged in that, I was a little embarrassed. That's 5 minutes. That's okay. Bullying, vilification, demeaning other leaders. We have shown what those leaders have done to the governor. The less I say about it, the better. They actually dared and threw the first stone when they had sinned more. Illegal appointments, I'll talk about this because this is statutory and I have an obligation to guide this Senate on the law. I will refer this Senate to section 64 of the County Government Act. It says, acting appointments shall be made only by the lawful appointing authority and for a specified period. It then says, nothing in this section, nothing that previous section has said shall prevent a public officer, like the governor here, like the county secretary, those are public officers, from deploying another officer to perform the duties vested in another office during temporary absence, during a vacancy that office. You will listen to the case of the county assembly. They will keep quiet on section 64, subsection 4, as if it does not exist. But let's move just further, senators. Subsection 5 says, if it comes to the attention of the County Public Service Board that a public officer has purportedly made an acting appointment, delegation, or deployment, as the case may be, contrary to the provisions of this section, the County Public Service Board shall take necessary corrective action. This is something that the law prescribes its own procedure of remedying. Why would we use a sledgehammer of an impeachment when the law actually prescribes a lesser restrictive measure that can solve the problem? That's what the county assembly has engaged you in. Naming a public road after the husband. Show us the road. Oh, let's go to Facebook. You'll find the... Surely, Senate has been engaged in that argument. I thought they would drop it in their final argument. Council stood here and insisted, we have produced compelling evidence in a Facebook post. That's elevating jokes to new heights. Contempt of the assembly. 1, tasked to explain where that offense is found in statute. The witness, of course, stuttered. The governor has contextualized all her responses to the county assembly. May I just inform this Senate? You have summoned the governors here who have said, let us go to court and interpret the scope of your powers as Senate to invite us, to interrogate us. And you have engaged them in court. That is development of our law. That is not contempt of the assembly. The governor ought to be praised. Is this governor a peacemaker? You saw her with MCS, launching projects in their wards, giving them the opportunity to shine by being the ones who read those projects. You are politicians. You know what that means in terms of dignifying and improving the stature of those MCS. I say, true to her word, this governor is a foremost peacemaker. It matters not whether she shall be brought here 100 times. You cannot victimize her because those who torment her are tireless in their torments against her. I beseech you, senators, to vote against each of these charges overwhelmingly in the interest of your individual and collective conscience. I rest the governor's case.
Senator Okiya Omutata, kindly take your seat. Take your seat, Senator Muma. Honorable Senators, ladies and gentlemen, following the conclusion of the closing remarks by the Counsel for the County Assembly and that of the Governor, Rule 27 of the Rules of Procedure when considering the proposed removal of Governor in plenary provides as follows: that the Senate shall proceed into a camera session to deliberate on the issues raised. I now therefore direct that all members of public, including the media, to withdraw from the galleries and any form of broadcast from the chamber to cease forthwith. The camera session will be held for only 10 minutes, after which the open session will resume as per the hearing program that has been circulated. Specifically, the open session will resume at exactly 10 p.m. Once we resume, the parties will be allowed to walk into the chamber and take their space. Members of public will be allowed to walk into the chamber. Media will be allowed back to the chamber. That is at exactly 10 p.m. Now, upon resumption of the open session, a supplementary order paper will be circulated. The Senate Majority Leader will give a notice of motion to facilitate debate. Debate will then ensue on the motion in the usual manner. And at the conclusion thereof, the Honorable Her Excellency KAWIRA MWANGAZA, the Governor of Meru County, will be given an opportunity to be heard. Thereafter, the Senate will proceed to vote on each of the impeachable charges. That is the direction of the Chair. Thank you.
Ladies and gentlemen, that marks the end of the hearing of the motion for the proposed removal from office by impeachment of Honorable KAWIRA MWANGAZA, the Governor of Meru County.